Hold up one
It's
finger
going,
when
it's
it's
going now.
okay. All right.
You should be
Okay.
able to call the case. Yeah.
Thank you very much. Please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont versus Michael Williams, case number 25 AP 422. Representing the appellant, Michael Williams, is attorney Marshall Paul. Representing the appellee, the state of Vermont, is attorney Claire Burns.
Thanks very much, and good afternoon, counsel. We'll hear from the appellant. Please start by introducing yourself, identifying your client, and then proceed.
Thank you, Your Honor. My name is Marshall Paul, and I represent Michael Williams.
Thank you.
In this case, the trial court, we are here on appeal of the same decision that we've been here on appeal before. And that's because the trial court made a modification to its decision that it was not permitted to make under any rule. The only rule that allows a trial court to modify a decision is Rule 36. And Rule 36 has a hard bar on any modifications to decisions, even the most ministerial, clerical, minor modifications, while a case is pending on appeal, which this case was. This case was still on appeal, on hold, on remand with specific instructions from this court when the court modified it. Now, there's a specific procedure spelled out in Rule 36 for how a court is to go about modifying a decision while the case is pending on appeal. The trial
would be to get leave of the court, to get leave from this court.
To get leave of the appellate court. And the reason for that, when you go back and look at Federal Rule 36, upon which Vermont Rule 36 is based, and Federal Civil Rule 60, which is also the basis for the Federal Rule 36, and is actually even more similar to Vermont's Criminal Rule 36 than Federal Rule 36 is. And when you look at the histories of those, they explain that the reason for that distinction is very important, and it's multiple fold. And the structural reason is jurisdictional, and that is to ensure that you don't have two courts acting on the same matter at the same time, which is sort of the axiomatic principle of subject matter jurisdiction, is that the point of subject matter jurisdiction is to ensure that only one court is weighing in on a matter at one time. And that's the purpose of Rule 36 provision requiring trial courts, even in the case of a clerical error, to seek leave of the higher court to correct that error, is so that we don't have two courts weighing in on the same decision at the same time, which is what happened here. And the harms that that's meant to prevent are exactly the harms that took place in this case. Counsel briefed this case twice. The court is now going to hear this case twice. The parties to this case, the victim and the defendants, or the defendant and the victims, have been through a roller coaster of sort of getting different news about the case. And all of that is what's meant to be prevented by the finality that's incorporated into Rule 36.
Mr. Paul, is your position then that because of Rule 36 and the trial court's failure to follow the procedure, asking leave from this court to reopen, that now there are two courts with jurisdiction over this issue, this appeal?
I think you would be incorrect to say that, because I think as a matter of law, as long as the appeal is docketed in this court has jurisdiction. I think the trial court's order was essentially an extra jurisdictional order. Okay. There is no such thing as two courts having jurisdiction over the same matter. And especially when it comes to appellate jurisdiction versus trial court jurisdiction, the law has been crystal clear. In the case of a final appeal, which this is not, the trial courts are divested of all jurisdiction. In the case of an interlocutory appeal, which this is, trial courts are divested of jurisdiction over any matter that is before the appellate court. And in order to proceed on any matter that's before the appellate court, they need to ask leave of the appellate court and get a specific instruction remanding for that. And that's to prevent exactly that issue, which is two courts having jurisdiction at the same time, which is kind of a legal impossibility, but is practically speaking what appears to have happened in this case.
Okay, thank
It's
you.
it's your position then that once the trial court went beyond what was specifically identified as the next steps upon remand in our order, that they stepped outside of their jurisdiction. Is that it?
Yes, and that for a lot of practical reasons, what the procedure there should have been to request leave of this court in this proceeding. That would have given, for example, that would have given the parties the ability to address this issue, because there is now a question, an open question, as to whether or not this correction is a clerical error or a judicial or substantive error, which follow very different rules. That question is a very factual question. It's not one that's been examined by this court much, but in other jurisdictions that have examined that question, there's all kinds of factors that weigh in it. The intent of the court weighs in it. The nature of the error weighs in it. The extent to which the parties may have relied on the error to their detriment weighs in it. The extent to which the error is going to affect ongoing proceedings weighs into it. Those are all factual determinations that are generally made at the trial court level, not at the appellate court level. That's why there's a procedure in Rule 36 that says if you're going to change a decision, it's got to be, and that case is on appeal, it's got to be done with leave of the appellate court, because otherwise it puts us in the position we're in here, where Mr. Williams, who deserves to have an appeal of the merits of his case, now has to have an appeal that's about a procedural issue that's really separate from the merits of his case and has to do with the jurisdictional authority of the trial courts versus the appellate courts. And that's exactly what Rule 36 tries to avoid. Is it tries to say, if there's going to be changes made to a decision, those changes have to be made in coordination with the appellate court and in coordination with the appellate process, and likely made on remand in the trial court so that the entire thing can be transferred back up to the trial court for appeal, if necessary.
All right, so Mr. Paul, let's say the court here agrees with you and says that the only jurisdiction the trial court had was to entertain the state's anticipated motion, which they had represented, they would be filing. So we agree with you that we still have jurisdiction. What happens next?
I think what we would be requesting is a remand to the trial court. I think that the trial court's order in this case should be viewed by this court as essentially a notice requesting leave of the court to make an amendment. I think that's a fair interpretation, not of what the intent of the order was, but what the effect should be read to be, because that would be sort of reading the effect to be consistent with Rule 36. And, even though that's reading a little bit into the court's order, that's not there. I think that in the interest of expediency, because this is a bail appeal that's now been on appeal for 2 months, in the interest of expediency, it would be for this court to read that as a request for leave of the court to modify the decision, and for this court to remand it to the trial court for a hearing on modification. And presumably, just based on what's in the order, I think I can guess what will happen, but there's no telling what will happen. What happens in a trial court, you never know. I think I had some expectations about what would happen at the weight of the evidence hearing in this case that did not turn out the way I expected. So you never know what's going to happen in a trial court hearing. And so I suppose I hesitate to predict that here in the appellate court.
All right. Thank you.
I'll move on to the other issue, which is the merits issue, just in the alternative if the court, I see you have one.
You have 1 minute, counsel. You've
Okay.
got 1 minute.
I'm going to reserve the remainder of my time for rebuttal.
Okay, thanks very much. We'll turn to counsel for the appellee. Please start by introducing yourself and your client and then proceed.
Thank you. My name is Claire Burns. I represent the appellee in this matter and am the state's attorney for Caledonia County.
Thank you.
Thank you. The state's position as to the revision of the trial court's order is purely that of a clerical error and the correction thereof.
Well, Ms. Burns, explain to me why this is, in your mind, a clerical error. It has clearly impacted the substantive rights of Mr. Williams. So how is, explain to me why you consider that clerical.
Certainly. Based on my review of the case law in Vermont in federal courts, consistently the lodestone issue is whether the error turned upon a change of legal reasoning, a reevaluation of the facts, required a bit more effort than simply a clerical error. That is, that in the preparing of the orders, it was a typo. And at this point, the trial court made no indication that it was upon a revisiting of the facts or legal analysis that the modification was issued. Instead, it was to correct an error. And indeed, it is the appellee's position that reviewing that initial order, the trial court did seem to indicate, despite that not met its burden, that it did find that the state met the burden of proving that the weight of the evidence was great. It wasn't a sufficiently evident error that I was prepared to request that the trial court modify that order. That was only for the trial court to be able to do, because only the trial court could know that order. But ultimately, it comes down to the fact that it was not based on a reevaluation.
In other words, the intent of the court?
Correct. And as to the question that Justice Reber inquired about as to what would happen next, and Attorney Paul's response that it be treated as a notice, that would inevitably have us returning for a third hearing, for a third appeal. That if that were treated as a notice, then I suspect that Attorney Paul, on behalf of his client, would file an appeal based on that order. Thus, we would continue the cycle that we continue coming back, and that would ultimately result in a grave miscarriage of justice, which is in part what was referenced in Ray Northeast as a matter that courts should avoid at all expense, particularly where we have something that is not a substantive. It has a substantive effect, absolutely, but that's not to say that it was a substantive error.
Ms. Burns, how do you square your position with Higgins?
If I may, one moment, refresh my recollection. That was a matter as to whether the trial court it didn't correct the error that was, it didn't comply with the remand in correcting that order. It was squarely opposed, actually, that its error was in contravention of what the reviewing court had remanded for the trial court to complete. It perhaps would have been prudent to correct the mandate to reflect intention, or for the trial court to reflect its intention, but it didn't do so in that case. Now, moving on to the merits of the matter, maintaining that it was a clerical error. The state posits that the weight of the evidence does satisfy the standard here, and would say that it squarely is distinguishable from certain of the cases that appellant referenced. First, the legal standard in Wright v. State wasn't necessarily abrogated on other grounds. The grounds upon which it was abrogated factored into the analysis regarding the sufficiency of the evidence, suggesting that the defendant Wright caused the unlawful killings. And that was because the Florida court was still applying a different standard for appellate review, and that's what Bush overturned. And irrespective of the legal standard, the factual bases were wildly incongruent in terms of the evidence linking the accused to the killing. Based on the facts recited in that matter, for instance, I dare to presume the place of the Florida prosecutors, but this particular prosecutor would not have charged the defendant as he was. And in State v. Hayden, the court cited the need to have placed the defendant at the scene when the crime was committed. In the present instance, we have a victim who was known to arrive home. She spoke with the defendant, and she was subsequently never seen leaving. She was next found dead. A rational inference would be that the scene of the crime was her home, where the defendant was at that time. Furthermore, in Hayden, they indicated that the defendant had never been seen with the weapon, which was apparently a crucial piece of evidence for the prosecution in that matter. In this instance, due to the medical examination of the decedent, it was determined that the victim died from strangulation and also suffered a blunt force trauma to her head. And the defendant, in the day after the decedent was found, was observed to have a swollen hand. He had injuries to his hands and arms. So that would be a rational inference to draw that he was, that the weapon as such, his hands and also the strangulation was manual. There are instances in where Vermont courts have repeatedly upheld homicide convictions based on circumstantial evidence. State v. I'm going to mispronounce this, I'm sure, Theriot. The court found that the evidence of guilt was great due to entirely circumstantial evidence where the child had an abdominal trauma. There was a narrowing down of the window within which the child could have died, who was present, who had the opportunity. Here we have a very similar fact pattern in terms of we're narrowing it down, we're winnowing it down in terms of the defendant here was present. There was a window of time in which this injury occurred. And as such, it would certainly merit going to the jury for deliberation as to whether the state had satisfied its burden beyond a reasonable doubt, which is greater than the rational inference standard.
You have 1 minute, counsel.
Thank you. Actually, I am content leaving it at that. Thank you.
Okay, thanks very much. How much time does the appellant have, please?
Appellant has 52 seconds remaining.
Counsel? You're muted. You're muted.
I apologize for that, Your Honor. I will try to make 3 points in 52 seconds. The first point is that it doesn't matter whether this was a clerical error or not. Any error, whether it's clerical or substantive, that occurs while a case is on the docket in the Supreme Court requires leave of the court to correct. My second point would be that as far as the weight of the evidence goes in this case, I think that it's a little bit of a mischaracterization to suggest that the evidence here shows that Ms. Daigle was with Mr. Williams exclusively during the period of time in question. What the evidence shows is that Ms. Daigle came to the home at 3:30 and that her body was found at 7:30. It's apparent, and my time is up. So I will just leave it at that. There was not evidence to show that Mr. Williams had exclusive connection to Ms. Daigle during the time period in question. Thank you very much.
Okay, thank you very much. Your time has expired. Please call the conclusion of the hearing.